Let's continue talking about what are the elements of sexual harassment. You know, there's some lawyers that actually recommend that before you have sex with anybody, that you have a consent form with the signature on it. And as extreme as it is, sometimes in the aspect of the world of sexual harassment, it's always the safest way, but it's relatively crude to say the least. But the aspects of what is unwanted activity by the harasser, when you start looking at some of the different aspects, especially like in the very first case, Mirador Savings Bank versus Vincent, a lot of prior sexual contacts were unwelcome, if not involuntary. A lot of firmly welcome activity may become unwelcome. Flirt, flirt, flirt. Oh, stop! Don't touch me! Don't touch me! Well, you have different things. You have the nonverbal communication happening, and then you have the verbal communication happening, and then you have the verbal and the nonverbal all in sync, except for the fact it conflicts with what happened prior to that. You'll have a lot of it happening in cases like this, and you almost have to go through and find out the circumstances behind the aspect of it, and sometimes you dive far deeper than you ever wanted to before. Here's the cool thing. Stop. When that happens, you stop. If you have that going on, then life is good. The only recommendation I have when it comes down to students, training them for the future, for them to be executives and leaders in the world of business, here's the rule. Should you ask somebody out on a date that works with you? The answer is no, but you can't change human chemistry. It's there. So the reality of it comes down to, here's the rule. If you do ask them out on a date and they say no, don't ever ask them out again, period. Your life will be better because as soon as you do, the second, third, fourth, fifth, 12th, 35th time, it's all unwanted. So make certain you pay attention to some of the simplest emotional intelligence possible. When somebody says no, no means no. Sometimes you have severe or pervasive activity going on in the workplace. Now that means it's constant, day in, day out. If somebody wears an outfit one day and somebody compliments on it, especially about the physical extremities and so on, then you have issues happening. Severe, pervasive mean it's a harassing activity. It's more than an occasional act. They accidentally brush, except they accidentally brush 17 times in a week. Then it's not accidental. Common sense isn't common. So make certain when somebody comes forward with a complaint, usually what's been going on, it's been happening for a number of times and occasions, and they're worked up the courage to come forward to say, this is going on. When they say that, do not drag your feet, you need to respond if you're in charge of employment law. More frequent physical or human occurrences, by the time it's all done, make certain that you're paying attention, you're focusing on the victim's right to do their job without unwelcome activities. Somebody shouldn't have to walk in the front door of your business and dread every single time they do. If they do, and you're oblivious to it, then shame on you. You really may not belong in leadership. You need to pay attention to what's going on around you, not just on your job only. Also, severe and pervasive, it's not a personal injury complaint. It's a sexual harassment complaint. Claims don't have to have findings of severe psychological harm to be actionable. You need to be able to have an environment where a regular person can come in and actually work in the comforts without being harassed. Discomfort may not be enough. Outcomes can vary. It just depends as to what the activity is and how often. Is it severe? Severe doesn't mean on a scale of 1 to 5. Severe doesn't mean a 1 or a 2. It doesn't mean one comment. It doesn't even mean 2 comments in a week. But if you have a daily activity on a regular basis, and you can count on clockwork when you first walk in, if you want to wear this outfit, or if you have this outfit and you wear it, and every time you do, somebody makes a comment, then you need to report that, or maybe stop wearing the outfit. Pay attention to what's going on. If you are the supervisor, you are responsible. That's how it works. So make certain that you're paying attention to what's going on about you. Your workplace is not all about the task. Your workplace is about leading a team, making certain you have a collegial place where everybody can come in without fear of being harassed or uncomfortable in the workplace. If you don't develop that, it could quickly generate the aspect of being severe and pervasive because it goes on a regular basis. Court's perspective has evolved since you really had the 1980s boys will be boys rhetoric. I'm sorry, that's cute, but we also have a thing called the reasonable person standard. When a reasonable person comes in and they're watching an activity and they can see an activity, this person is uncomfortable. If a reasonable person feels that way and you walk in and you're the boss, you're the leader, and you don't see it, you need to sit down and improve your vision overall. Boys will be boys will not be inappropriate. Recently in Irvine, California, a very famous software company that makes some of the top selling video games, they had a boys will be boys rhetoric, and it was pretty much the judge ruled that it was kind of like a frat house mentality where all kinds of different aspects was happening in the workplace. Don't be part of it. Make certain that you're dealing with it and make certain that you are not the one responsible for putting blinders on and pretending that boys will be boys. The rhetoric is cute. It sure doesn't hold up in front of a jury in court. The reasonable victim standard, viewing the harassing activity from the perspective of a reasonable person in society at large. If it's somebody who walks in and they see that happening and you've done nothing about it, in all probability, then you probably have a difficult situation and you'll probably not win a court. Every time we talk about sexual harassment, the perspective is how would it be in front of a group of jurors watching the case? Is the activity that happens in your workplace, if somebody wrote a story about it, could it be published on the front page of the local newspaper? If they did and it was absolutely boring, then you probably have a good workplace. If it did and all of a sudden eyebrows are raised and people want to get the next copy of the newspaper because it's so juicy and seamy, you probably have a problem. So make certain it's gender specific in the aspect of sociological, cultural, and other factors. Make certain the harassing activity doesn't happen and that people wouldn't be all that interested except for the product that you're producing. The EOC issued a policy statement. It required the victim's perspective must be considered so as not to perpetuate stereotypes. The boys will be boys, that's a stereotype. The notion, a reasonable woman, a reasonable victim standard. You really use that really by the time you're all done, and it's a measurement by the court looking at the aspect of, and here's the exact statement, the objective severity of harassment should be judged from the perspective of a reasonable person in the plaintiff's position. That is always a standard that we use when measuring whether or not sexual harassment is actually harassment. Would a reasonable person, and what is the reasonable person? Well, hopefully it would be the average person walking down the street. If they see that, they would determine that. A lot of times when we talk about sex, harassment behavior, it doesn't need to involve sex, request for activity. It could also be anti-female. I have also seen formal complaints for anti-male. They could be just as big between the two of them in the aspect of anti-female, or they want to have a culture where it's all female in the process and the male intrudes within an environment. That is just as caustic as it is with the anti-female, and so you really have to pay attention to what's going on no matter who or what or where is taking place. So, and you'll also, I want to make a comment here about electronic media. A lot of it really needs to have a lot of policy attention and monitoring, especially about what's going on within the workplace as the aspect of reasonableness. Supervisor toward employee on the aspect of tangible action taken, make certain normally it involves quid pro quo. Employers should be liable for the acts of their supervisors. That's how it works. The employer is responsible for the supervisor. Sometimes the employees are doing the things and the supervisor may be oblivious to it, but if your supervisor is oblivious to it, you need to sit down and get a new supervisor or some really good training to make them oblivious. Give them a sense of emotional intelligence. A paper trail regarding the different actions that's involved with it. That helps give you some type of control. Make certain your evaluations are current. Sometimes you may want to do a 360 evaluation on the different supervisors so you have the input of numerous different constituencies as to whether or not they're doing their job. And make certain if that happens that you review them thoroughly. That's probably one of the better forms, although it can be exhausting sometimes. Then Allers versus Farragher, the employer had a reasonable sexual harassment policy and harassment, and the harassed employee unreasonably failed to use it. They didn't report concerns to the company. You certainly have a lot of people that fail to bring things forward because they don't want to be picked on. They don't want retaliation. They want it just to go away. Sometimes supervisors need to get their head out of the sand and pay attention to what's happening, but sometimes a supervisor simply may not know because the person doesn't give any indication that something bad is going on or they're uncomfortable. Make certain if you're the employee that happens. Make certain also that if somebody reports something, that retaliation doesn't take place. Employer liability, coworker harassment, or third-party harassment of the employee, make certain it's all there, that you're training people, and even if it's a third party, like the delivery person coming in who doesn't work for you, just drop things off, make certain that things are happening, that you're dealing with them. The employer is liable for acts that happen if it's known, yet no corrective action is taken. Talk about it, deal with it, train your supervisors, make certain the elements of sexual harassment that it's unwanted, severe and pervasive if it's always there on a regular basis and somebody's uncomfortable coming to work. One time only, non-reoccurring events can happen. Somebody makes one gesture, one comment, and all of a sudden, boom, they make a complaint. That is not severe and pervasive, especially if it's being dealt with on a regular basis and quickly. The reasonable person standard is the measurement that almost all courts will use. Would a reasonable person view this as sexual harassment? And also, would a reasonable person look at this and say, did the employer act, train, or try to avoid a sexual harassment situation in the workplace, making certain everybody's comfortable? That's also a reasonable standard that we look at. Take care.